is very important. You can't say, sorry, this is not voluntary, it's mandatory. I'll come back to the mandatoriness. And there are some members of the United Nations who have grumbled about the fact that this is a no-choice mandate which they have been given, and they are forced because of the Chapter 7 resolution of the United Nations Security Council. Although, they, of course, as a commitment they have in both words and deed to non-proliferation. Initially, India also made noises with respect to what was called the intrusiveness into national sovereignty, and there is a certain element of intrusiveness, and this very distinguished audience will recognize immediately that there is, when it deals with the larger issue of the relationship between nation states and the United Nations, and in particular the authority of the United Nations Security Council to act somewhat beyond national jurisdictions. This is a slightly larger issue. Anyway, one of the requirements of the resolution is that states have to report to a committee widely known as the 1540 Committee. I had the privilege of serving this committee as an expert for 2 years in New York on the legal and the regulatory steps that countries and nation states have taken to implement the resolution, namely Resolution 1540. Now, one of the several noteworthy elements of Resolution 1540 are the following. It requires states by law within their own countries to criminalize WMD proliferation, particularly by non-state actors, essentially by non-state actors, including activities which aid, abet, support, facilitate, or finance such activities. So it's actually second order and third order. There are itemized requirements. There's comprehensive export controls to ensure that things don't go outside national borders without the authority or the knowledge of government. Incorporate international obligations into national law, ensuring that all the laws that you have domestically are concordant with or are in compliance with. We use the word compliance, and there's been a bit of a problem of that use, but so at least they have to be concordant. In other words, there should be no disjunction between national law and the requirements of the United Nations Security Council Resolution 1540. Cooperation between states with regard to illicit trafficking in goods relevant or pertinent to proliferation of weapons of mass destruction or the means of their delivery, such as missiles. States are required to have specific law-backed instruments, such as controls at the border, such as lists of items which are required to be controlled before they can be exported, such as ensuring that the entire spectrum of activities are also controlled besides the goods themselves, such as, for example, the intangibles, the knowledge which is resident in the manufacture of these goods. That's also controlled. Of course, there are facilitations because various countries are at various levels. Facilitations are available to ensure or to ask the United Nations to provide assistance so that countries which are at various levels of development to either assist each other or to ask for international assistance for formulating and implementing laws of this kind which I have just adumbrated. Now, there is a lot of information, it's in the open, in the literature, and it's also on the website, and you can go to the website of the 1540 Committee. There are national reports on what they have done to implement it. There's a database of pertinent legislation so that one country can learn from another. And of course, there are reports of the 1540 Committee themselves. There are now 3 reports, 2.5 really, so you can have a look at those. And they're all available on the website of the United Nations Security Council 1540. Now, the value of this information in the preparation of national legal instruments is often underestimated, actually. For the first time, all this information is publicly available. It's very difficult to get hold of the laws of other countries which are pertinent to a particular requirement that you have. But all of these are now available on that particular website. And very often they're available in a language which is understandable. They're, of course, the 4 main languages of the United Nations, provided they're provided by the original state. It has also, it has also enabled incremental harmonization between the various countries of the laws without their being identical. And of course, it has enabled the enhancement of supply chain security within countries. See, it's not enough to control something at the border like this. And for example, this may contain, let's say, poison that you want to control. You may want to use this poison because it's dual use. You use it for quite legitimate purposes within the country. In fact, most of you, as you've been looking at this for a period of time, there is a part of the resolution, the subsequent resolution called Resolution 1810, which urges the 1540 Committee to see whether a certain degree of harmonization cannot be brought about between the legislations of various countries by a matter of interaction and persuasion, and by telling them that if they do that, then they have a much greater advantage in ensuring, because very often what happens by certain, if you want technologies from countries, and we are now imposing this incidentally, many countries in Africa or some other places want our technologies of a certain kind, not the ordinary kind, but some kinds which are controlled by our own list, and we tell them we have no problems about giving this to you, but please ensure that inside your own countries, we can be sure that someone from, let's say, Nigeria, to whom we are quite happy to transfer a technology, is not in a position to take it away and go to Sudan, and from Sudan it can go to Ethiopia, and from Ethiopia to Dubai, and from Dubai to Pakistan. So we have to ensure that the entire chain is reasonably secure, so that one of our control technologies doesn't sort of, is legitimately exported to a country, but then it illegitimately be exported from that country to some other place. So that is why it becomes necessary to have an international web of nearly identical laws and regulations and practices to ensure that what goes from one country to another as a matter of legitimate trade doesn't end up in some other third country or fourth country as for illegitimate and illicit purposes. Now, national practices of various kinds, and India has offered its assistance. India is one of the first countries to implement a law of its own called the WMD Act, and I'll come to it in a minute, which essentially offered to other countries nearby and not so nearby, including Suriname and places like that, Mauritius, which to say that if you have a basic construct of law, and I think I'm sure this very distinguished audience recognizes that Anglo-Saxon law has a certain framework associated with it, and we are all sort of derivatives of that Anglo-Saxon law, for the most part, insofar as post-independence is concerned, and even before that. And I need to tell this audience that members of the Commonwealth, who were all colonies of Britain, have a certain structure of law which is very similar. So, although there are difficulties and there are obvious negatives for that, certainly it makes it easier for Commonwealth countries to interact with each other when it comes to helping each other for laws of the kind that I've just mentioned. And so, one of the tasks of the 1540 Committee is to match assistance providers with those who need it. But that is a sort of an administrative kind of a task. Resolution 1810, which was passed in 2008 by the Security Council, does one very important thing. It connects up United Nations Security Council Resolution 1267, which deals with Al-Qaeda Taliban, which is a sanctions committee and a sanctions regime for those who assist Al-Qaeda and Taliban. It connects it with United Nations Security Council Resolution 1373, which is a counter-terrorism regulation, or a counter-terrorism resolution really, which requires, again, under all three are Chapter 7 resolutions, and they are required, countries are required to put in practices which ensure that terrorists don't operate internationally or even nationally, and 1540. So there's a connectivity between three, and 1267, for example, on Al-Qaeda Taliban, are sanctions on identified people and movement across borders. For example, Pakistan has been regularly in violation of 1267 because it allows all these people to go to Afghanistan. Forget about India, that's another issue. The resolution 1373 is for in-country, rather than border, legal and regulatory measures against terrorism in country. And 1540, as I just pointed out, is of course export and border controls over, largely, there are some other elements also, over goods and knowledge relevant to weapons of mass destruction and their delivery systems, mostly missiles, but also others. And the three committees and their experts groups serving them, in the United Nations are mandated to identify the coordination between them, and as a result of this coordination between the experts, there is a tendency to, not more than a tendency, they assist the committees to coordinate the work. They come at different times in history, and therefore, since they were not simultaneous, the structures under which they have been created are very different. And the historical circumstances are were different, and therefore the coordination is not that easy. Now, let me come back. This is the international scene. What about our own effort here in India? Now, India's corpus of laws dealing with activities that are relevant to preventing the proliferation of weapons of mass destruction and means of delivery is quite large, and it's quite a large corpus actually. It includes, for example, the Atomic Energy Act, way back in 1962, the Customs Act, 1962 again, the Foreign Trade Development and Regulation Act of 1992, the Chemical Weapons Convention Act that was alluded to by my colleague and chairman, that was passed in 2000, which was meant to implement India's obligations under the Chemical Weapons Convention. Then the Unlawful Activities Prevention Act in 2004, and lately, of course, the Weapons of Mass Destruction and their Delivery Systems Prohibition of Unlawful Activities Act of 2005. Now, the last was specifically enacted to fulfill India's obligations under UNSCR 1540, and it criminalizes WMD proliferation activities. Its provisions apply to, the others don't. The provisions of the WMD Act apply to citizens of India outside of India, who are resident outside India. Therefore, it applies to NRIs. NRIs, not PIOs. Although probably to their wives as well, but anyway, that's another matter. So the issues that will arise in the legal community now is increasingly so as India develops technologically, and these complexities of the way in which technology is used both domestically and abroad, and the way in which we trade with other countries, we have come into a fairly complex regime where issues in trade law, of which many of you are very familiar, now get to be at the confluence of technology on the one side, foreign policy on the other side, national security on the third. So you have a triangular relationship between international law, national law, foreign policy, national security. This triangle and the law and the legal regime which essentially binds this triangle together conceptually and procedurally is, I believe, something which is quite new in our country, and something which will in fact more and more impinge on your work as legal people, both on either side, whether you're on the bench or whether you're an advocate or a solicitor or whatever. You will certainly find that over a period of time, many of the issues that you will be dealing with, many of the points and many of the cases that your clients will bring to you, and I should tell you that they will be very lucrative, will involve this triangle. And now, I'd like to point out a kind of issue which will arise in the future. Let me just elaborate this. See, in some countries, such as most prominently, but not exclusively, the United States, trade is a privilege. It's not a right. And this is a constitutional provision that the United States has. It goes back for many years. It's also trading and so on. It's a constitutional provision, right? Okay. So, in the U.S. Constitution, it provides and says the state can or cannot prevent, may or may not prevent trade. It's not a right of an individual. It's the prerogative of the state to allow you to trade. Now, in India, it's a right, as granted by the Foreign Trade and Developmental Act. It was not so. So I'll come back to that in a minute because it's important for this. Consequently, what happens is that in U.S. courts, when a case comes up like that, they don't question the grounds or the equity and fairness of the control that has been exercised because it wasn't a right in the first place. Okay? So if you quote national security or foreign policy reasons of the executive to deny the privilege in specific cases, and it is a privilege, then what happens is that the courts do not actually question the basis on which that decision was made. Now, violators of law, therefore, have the option to settle fines and other punishments by plea bargaining. Now, when you do plea bargaining, you also have the opportunity of gaining a lot of, say, national security-related intelligence from those who go about doing the plea bargaining with you because they know that they're going to be in very serious trouble, and therefore you can do a deal. Now, you can do this in a country like the United States where trading is a privilege granted by the state and is not a right of the individual or the company. Now, the question that will arise here is,